Okay, then who wins the toss chooses the side, either the plaintiff or the defendant. Uh, hmm. First of all, any one of you choose in which hand is the coin. Which hand? Cards. Heads or tails?
Heads. It's tails.
The defendant side.
Your team.
19.
Just to be clear, it's plaintiffs and team 19 is the defendant. Please read the memos accordingly. Okay. Please have a picture. Please. Come. Now. And we'll be starting with the final rounds in just 5 to 10 minutes, so please be ready. I request all the ushers, please bring your team from the camp along the hostels so to witness the final rounds, right? We'll be starting in 5 minutes. And details are on. It is requested to the teams. They can take their respective places, please.
Good morning. Good morning.
Hello, 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 hello. Check. Hello, hello, hello. Check. On ही रखे नंदू.
Good morning. Good morning. Good morning.
एक साथ में ऑन रहेंगे. ठीक है. फिर वहां पे एक तो माइक चाहिए उस पोडियम.
Good morning. Good morning.
Hello, hello. Hello, hello, hello. Hello.
I think this will be fine. It's not a problem. Yeah. Perfect. Thank you so much.
पीछे खड़ा हो जाऊंगा फिर मैं लिखूंगा, वो आप देख लीजिएगा. You will need it.
I don't need it.
Yeah. And the
Hello, 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 hello.
The court is now in session.
Does the speaker have permission to refer to the judges individually as your ladyship and collectively as your ladyships or the bench? Much obliged. In the matter today before the Honorable High Court of Melba, the counsel for the plaintiff shall be represented by me as Speaker 1 and my co-counsel as Speaker 2. I shall be arguing about the first two issues as given in our written submission. If your ladyships may please have the statement of issues as given in our written submission. I shall be arguing upon the first two issues. The first issue being the finality of the settlement agreement in the light of the alleged averments of coercion, and also upon the second issue, which is whether the defendant is owed or has any claim for any sort of compensation or any sort of damages under the contract for a total time of 16 minutes. And my co-counsel will be dealing with issues 3 and 4 for a total time of 16 minutes as well, which are given as issues 3 and 4 in our written submissions, your ladyships. Would your ladyships want to be apprised with the facts of the present matter?
In brief.
Indeed, your ladyship. To begin with, the parties here, the plaintiffs are AGEL or Adhan Green Energy Limited, and the defendants are SWCL or Solar Water Corporation Limited, which is a public sector undertaking controlled by the government. Both of these parties entered into a contract in July 2023, which was in order to create a solar water desalination plant, solar hydration desalination plant for the benefit of the people of the southern region of Melba. According to the contract, milestones had been set up, and for milestones, specific payments also had to be made. However, when the contract began on 31st July 2023, for the first few months, the contract progressed smoothly. The work for the milestones completed by August, September, and October were completed according to the time. However, the defendant caused the breach of contract by not paying for the milestones completed by September 2023 and October 2023. Consequent to this breach, the plaintiff had sent various communications to the defendant regarding this particular breach and how the lack of a payment from their side was causing economic starvation and was actually hindering the plaintiff from performing their own obligations for the further milestones, your ladyships. But the defendant paid no heed to that. The defendant did not respond to these particular communications, and consequently from the months of November 2023 to March 2024, the milestones that had to be completed by the plaintiff suffered a bit due to the facts that I had stated before. Consequent to this, on 1st April 2024, this is the date when the defendant issued a letter of termination, unilaterally terminating the contract against the plaintiff, saying that at the end of the month, that is April 30th, 2024, the contract shall stand terminated, and they also illegally altered the scope of the contract through this letter of termination, your ladyship, which is to be pertinently noted. Based on after this, in the spirit of amicably settling disputes, the parties had entered into settlement talks in the month of May 2024. These concluded on 31st May 2024, and based on these settlement talks, there was a settlement agreement which was arrived at between the parties, which was finally effected on 10th June 2024. However, it is the contention of the plaintiff, and I shall be arguing about it, that the particular settlement agreement that had been entered was entered into under coercion. These were the facts in a nutshell, your ladyships, and after this, there were a few hearings before the Honorable High Court of Melba, and today this is the final hearing before the present for your ladyships. If your ladyships are apprised with the facts of the present matter, may I just have 30 to 45 seconds to satisfy the court with regards to the jurisdiction?
Please do.
Much obliged, your ladyship. If your ladyships may please have a statement of jurisdiction as per our written submission, which is given on page 11 as Roman numeral 11 of the plaintiff memorial, as well as having it with a conjoint reading of the prayer that we have given.
Written statement.
May I continue, Your Lordship, Your Ladyship?
Yes, please.
Much obliged. When we consider the statement of jurisdiction as well as our prayer together, it is very clear that this is a commercial dispute which falls under the jurisdiction of the Commercial Courts Act, and I shall be proving it in a three-pronged argument. Firstly, the present dispute qualifies as a commercial dispute to begin with, because a commercial dispute is very specifically defined under the Commercial Courts Act under Section 2, subclause C of the Commercial Courts Act. Just to give you a brief, the Commercial Courts Act Section 2, subsection C gives various heads as to what a commercial court is, and if your Ladyships will please have the Commercial Court Act as well with regards to the present contention. Clause 6 of Section 2, subsection C of the Commercial Courts Act clearly states, and I quote, that construction and infrastructural contracts, including tenders, are also included and are also construed as commercial disputes. This was the first point, Your Ladyship. The second point is that of specified value under the Commercial Courts Act. Specified value is defined under Section 2, subsection I of the Commercial Courts Act, which clearly highlights that there is a lower limit, which is, if the counsel is not wrong, is prescribed to be 3 lakh Indian rupees. And since the present and through the conjoint reading of the prayer, we can find, and through also a conjoint reading of Section 12 of the Commercial Courts Act, it can be found that since the monetary value that we are seeking is way above this lower limit, therefore we also satisfy the claim of it being a specified value under a commercial dispute. The third prong of this argument is it supposes a few facts, if I may put them before your Ladyships. The third point is that the High Court of Melva has its own commercial division, which is very important for it to have original jurisdiction over the present matter. This can be seen from Section 2, subsection D of the Commercial Courts Act, which says that every High Court having original jurisdiction should have its own commercial division, which is also which also conforms to Section 4, subsection 1 of the Commercial Courts Act. And through these points, jurisdiction is derived from the Commercial Courts Act under Section 7 of the Commercial Courts Act, your Ladyships. If your Ladyships are satisfied, I humbly apologize. I believe judgments may have been submitted to your Ladyships pertaining to R.D. Shetty versus International Airports Authority, which should have been supplied by the court officers. This particular judgment has been given challenging the jurisdiction as has been given in the written submission of the defendant memorial, your Ladyship, because the defendant in their memorial have aroused the writ jurisdiction of this particular honorable court, which in this particular aspect should not be considered. It is my humble contention, primarily because of the fact, if we consider paragraph 1 of the Moot proposition, your Ladyships, if your Ladyships will please have paragraph 1 of the Moot proposition, it clearly highlights that SWCL is incorporated under the local laws of India, and it is a PSU that is controlled by the government of India. Now, it is in general parlance also, control is defined under very specific heads. It could be a financial control, there could be an apparent control, there are various heads under which control also has to be satisfied. And that is why I have submitted R.D. Shetty versus International Airports Authority, and the paragraphs have also been highlighted for the consideration of your Ladyships, because the defendants in their written submission do not satisfactorily argue or contend as to why the defendants are a public sector undertaking, what sort of control they have, what sort of control the government has over them, how much is the control, which is specifically mentioned and has to be mentioned according to the present judgment that has been submitted, your Ladyships. If your Ladyships are satisfied with the jurisdiction, may I please proceed with my issues?
Yes.
Much obliged. With the permission, much obliged. So for my arguments, your Ladyships, I shall first be giving you a structural overview of what the two issues will entail. Firstly, for the first...
I have a question.
Much obliged, your Ladyship.
With regard to the jurisdiction, as you just said, and you referred to the Commercial Courts Act as well.
Indeed.
When the main contract that was entered into between the employer and the third party, or these two parties, was there an arbitration clause in that contract?
No, your Ladyship, there was no specific arbitration clause. However, clause 9B of the contract, if I am not wrong, I believe it is clause 9B, it states that the Honorable High Court of Melva shall have disputes over all, have jurisdiction over all disputes that arise between the relations of the parties.
So there is no arbitration clause in the agreement?
There is no specific and very explicit arbitration clause, your Ladyship.
There is no specific. Is there something called non-specific? I mean, either the arbitration clause is there or it's not there.
Your Ladyship, with regards to the arbitration clause, there is only clause 9 which pertains to dispute resolution, and clause 9 only has two particular subclauses which does not specifically refer the disputes for arbitration. Arbitration in itself is a legal proceeding which has its own governing sections and act itself.
So does this agreement give rights to the parties to resolve their dispute through arbitration or go to the courts for resolution of disputes?
The particular contract says that the party should go to the courts for the resolution of disputes.
Okay. And when the settlement takes place between the parties, as a result of which or the termination of this contract happens, then this is a survival clause that the parties could go and resolve their dispute through a court of law.
Indeed, Your Lordship.
Go ahead.
Much obliged. If could I please know the time that is remaining, if Your Ladyship may permit? Indeed, Your Ladyship. I shall be continuing on the first issue, which is pertaining to how coercion is actually satisfied and how coercion was actually employed upon the plaintiffs in the present matter, Your Ladyships. So for this, my humble contention is that yes, coercion was employed and it could be proven through the Contract Act. It can be proven through judgments that I shall be submitting shortly, and it can also be proven through the concept of economic duress or economic coercion, Your Ladyships, which is a concept which has been borrowed from other legal jurisprudences, but it is still applicable through another judgment which I shall be submitting, Your Ladyships. Firstly, when it comes to the Indian Contract Act, and if Your Ladyships may please have section 15 of the Indian Contract Act, Your Ladyships, because section 15 of the Indian Contract Act clearly highlights that there are two conditions under which coercion may be satisfied. Firstly, if there is any act that is threatened to commit, that is being threatened to commit, or is actually committed, which is punishable under the IPC, or if there is any detention of property, or if there is any threatened, or if there is any threat to such detention of property, either of these conditions shall satisfy that coercion has actually been employed under section 15 of the Indian Contract Act. It is my humble contention that the second criteria, which is the detention of property, has to be considered, primarily because of the fact that, and I shall be enunciating upon it further, that invoices had been raised and such invoices had been converted into payment that had to be given to the plaintiff, which was withheld, and this payment constituted the property that had been detained, and since it had been detained, it qualifies under the definition of coercion under section 15. With regards to other submissions as well, it can be seen that there are two particular landmark cases which have broadened the scope of economic duress as we understand it in our Indian legal jurisprudence as well. Firstly is the case of Pao On versus Lau Yi Long. It is a case of the Honorable High Court of Hong Kong, and if your Ladyships may please refer to our written submission, it is given on page 3. It is the first sentence on page 3, and for your benefit it is citation number 23. This particular judgment, read with the judgment that must just have been submitted to you, which is ONGC versus Daiichi Karkaria, which is a 1993 judgment, and for your benefit, it is given on page 2, paragraph 3 of our written submission and citation number 11. Both of these judgments have contributed significantly as far as the Indian legal jurisprudence is concerned about the concept of economic duress. And both of these judgments in concurrence, they state that to constitute a claim, to constitute a successful claim of economic duress, there have to be two conditions that have to be satisfactorily met. Firstly, there has to be a lack of practical choice available to the person who alleges that economic duress has been employed on a person. Secondly, there has to be the employment of illegitimate pressure as well. And these two criteria have to be satisfactorily met, and it is my humble contention, which I shall be enunciating further, that these are satisfactorily met according to the facts of the present matter, Your Ladyship. As far as the facts are concerned, if Your Ladyships may please refer to paragraph 4 of the Moot proposition, because paragraph 4, and I'm specifically referring to the last few lines of paragraph 4, because these sentences highlight how the defendant had actually breached its contract by the non-payment of the months for the months of September and October 2023, when invoices had duly been raised by the plaintiff as given under the contract, Your Ladyship. Your Ladyships. And further, as just to enunciate and just to give emphasis on the fact, invoices had duly been raised, and so the plaintiff had complied with its obligation. However, the defendant, causing the breach of the contract, did not conform or did not fulfill their obligations under the contract. Further, it can be seen that the milestones that had been so missed by the plaintiff in consequence, they can directly be attributable to the fact that the defendant had not made payment for the months of September and October, especially when it was highlighted very explicitly by the plaintiff that such non-payment could lead to economic starvation, could lead to the project itself being hindered and hampered, which was not taken into consideration by the defendant, your ladyship. Combined with this is the fact that combined with this is the communications that had been made or that took place between the parties. Especially what I'm referring to is paragraph 10 of the Moot proposition, your ladyships. If we read the terms of the settlement given under paragraph 10, your ladyships, it can be clearly seen, and if I may please specifically refer to subpoint B of paragraph 10, wherein it is very clearly mentioned that SW, and if I may quote from the Moot proposition, your ladyships, SWCL will not impose any delay LD and milestone LD on AGEL for the delay in completion of the work on the project. Additionally, SWCL will not impose additional costs on AGEL that it incurred for the employment of Mensa Energy. This very clearly highlights, and this is the main crux of why economic duress has been fulfilled, is that because there is a pressure being employed on the plaintiffs. Secondly, there is a lack of practical choice in the sense that if the plaintiffs do not agree with the terms of the settlement, then they will have to face other claims of litigation, they will have to face other claims by the defendant, your ladyships, which is not even owed by the plaintiff to the defendant. Furthermore, even if we keep the arguments pertaining to coercion aside, even then there is still a question on the finality of the settlement agreement, your ladyships, mostly because of the fact that there is a settled position of law. I humbly apologize, I do not have the submission, I do not have the case to submit to your ladyships, but if your ladyships may please refer to page 5 of our written submission. This is citation number 39, your ladyships. This is the case of Rebuttal Company versus Kerala State Science and Technology Museum. It is a judgment by the Honorable High Court of Kerala, and the Honorable High Court of Kerala, after considering may I please?
Yes, please continue.
The Honorable High Court of Kerala, after considering a catena of judgments, it finally opined and finally laid down in law that when a party breaches a contract, then the party who is aggrieved by the contract is owed all other losses, all other damages and all other compensations that are incidental to and that are connected to such breach of the contract. With this I conclude with my first argument pertaining to the finality of the settlement, and if your ladyships are satisfied, I would like to move to there being no valid claim of delayed LD and milestone LD by the defendant. May I proceed, your ladyships? Much obliged. I understand I have a paucity of time. I will just take 2 minutes to much obliged, your ladyships. Firstly, I would just like to highlight the framing of the issues in the Moot proposition as well as in the statement of our issues. It clearly mentions that is there any delay LD or any claim of delay or milestone LD under the contract, which means under the mutually agreed provisions or under the mutually agreed obligations of the contract. This is something that I wanted to give emphasis on, which I will come back to later. So just a primary submission in this particular argument is that a defendant was in violation of the doctrine of clean hands, your ladyship. And what the doctrine of clean hands is, if I may please submit another judgment before your ladyships, which is the particular case law I'm referring to is Ramjas Foundation versus Union of India. And your ladyships may also have it on page 7, paragraph 17 of our Moot memorial, and citation number 60 for the benefit of your ladyships. This particular judgment has been, and paragraphs have been highlighted, and this particular, may I continue?
Yes.
And this particular judgment clearly highlights the extent and the application of the doctrine of clean hands. And it clearly states, and this is also reverberated in various other jurisprudences, this is also reverberated in the Halsbury laws of England, your ladyships, wherein it is very clearly stated that a litigating party which seeks equity must come to the court in equity. And this has been violated by the defendant because it had incurred various breaches of the contract. For example, it illegally altered the scope of the contract, which is given under clause 3 of the contract. This particular thing can also be found in the facts of the case. When the defendant issued the letter of termination, and this I'm referring to para number 6 of the Moot proposition, ladyships, because para number 6 clearly says, para 6A in particular, it says that the scope of the work under the contract has been reduced to 50%. And if we refer to clause 3 of the contract, it is very clearly given that even though the defendant has the power to alter the scope of the contract, it cannot be more than 36%, which is a clear-cut violation and clear-cut breach of the contract. Secondly, as I stated before, payments that had to be made for the months of September and October under clause 4B of the contract has also been violated by delayed payment. Furthermore, if I just may have one minute to submit just the last leg of my argument. It pertains to section 54 of the Contract Act, your ladyships. And if your ladyships may please have it, section 54 is of vital importance. In fact, section 51, 52 and 54 in a conjoint reading are very vitally applicable to the facts of the present matter. If your leadership may please have section 54. First of all, it has to be established that in this particular contract, there is a reciprocity of promises. This particular contract entailed reciprocal promises. And this can be clearly seen again from clause 4b of the contract, because only when the plaintiff completes a milestone and only when an invoice has been raised against this completion, only then will the obligation of the defendant will arise in the matter of payment. This clearly means that the obligation or the deliverance or the performance of the defendant cannot be claimed unless, firstly, there has been a milestone completion and a successful invoice has also been raised against it. Which takes me back to the facts of the present matter of paragraph given under paragraph 4, your ladyships, where, and I'm reiterating, I know I've already said this, but milestones have been completed for the months of September and October. Duly, the invoices had been raised. However, there was a breach of contract and there was a non-performance on the part of the defendant. And here section 54 comes into play because it very clearly highlights, section 54 very clearly highlights that the performance of, if a reciprocal party does not perform its own obligation, then it has no further right, or it has no right in law to claim the performance of the other reciprocal promisee. And which is why, and not only can it not claim the reciprocal promise, it also has to give compensation for its own non-performance, your ladyship, which is why there is no finality as well in the settlement agreement, which is why you're also owed other compensations, which is what my first issue entailed, your ladyships. Please, your ladyship.
Can you please point out from the contract, which is the provision on which you are relying upon to develop this argument? You say that there was a reciprocal obligation.
Indeed.
The idea is who is performing that obligation, who has under the contract an obligation to perform first.
Indeed.
And who had done the follower breach.
Indeed.
So could you please point out from the
Indeed, your ladyship. Much obliged. As with regards to the Moot proposition and the terms of the contract, please refer to clause 4b. Clause 4 refers to the terms of payment, and clause 4a. Clause 4b, I humbly apologize, your ladyship. Clause 4b clearly states that the employer shall make a payment for each invoice raised by the contractor within 30 days of the receipt of the invoice after deducting the amounts towards advance payment. So clearly, firstly, the employer has to complete its own obligation, which is the completion of the milestone, which was done for the months of September and October. Secondly, a duly recognized invoice has to be raised, which was also done according to the facts of the present matter given in paragraph 4. Thirdly, this is when clause 4b comes into play, your ladyship, which is when the obligation of the defendant comes into play in actually fulfilling the payment which has been raised under the invoice, which has been breached for the months of September and October, your ladyships. Yes, your ladyship. Indeed, your ladyship.
What is the remedy available with you?
When there is a breach, it is usually gone under section 73 or 74, depending on whether. Indeed. Your ladyship, I humbly accept your question, but it was not a unilateral decision, or it was not a conscious decision of the party, of the plaintiff, to go slow with the contract. And if I may please refer, and if I may please refer to the Moot proposition again, paragraph 4 of the Moot proposition, again the last few lines, it very clearly highlights that, and if I may quote from the Moot proposition, your ladyship, that on AGEL on multiple occasions requested SWCL for payment of its invoices for the months of September 2023 and October 2023, as the non-release of the payment was causing severe financial distress to AGEL, which would ultimately impact the progress of the project. This had been at this point.
you thought that without the money you cannot continue, why did you not give them a notice of termination or seeking money?
Your Lordship, Your Ladyship, to answer the latest question, why we did not terminate the contract at the very moment is because and paragraph 1 supports my contention that this particular contract had been entered into for the benefit of the people of the southern region of Melba. We understood the gravity, we understood the public nature, we understood the how many people it would affect, and that is why also clause 9, which is clause for the contract for the clause for the dispute resolution. It also states that all disputes have to be settled, must be settled amicably between the parties. Any sort of litigation against the party claiming compensation, as is right now, it had the potential to turn adverse, and it had the potential to harm the relations of the parties at that given moment, which is why it was not Section 73 or any other remedy had not been sought, and in the interest of the project, it had been undertaken.
May I ask a question? At the time of settlement, when both parties had disputes, there is a principle which comes into play, and that principle is called the principle of waiver. Okay? So both parties have disputes, as ma'am rightly pointed out, that if AGEL had problems and felt that there was a breach of the contract, the remedy for breach of the contract could be seeking damages or specific relief under getting a specific performance of the contract. It did neither. Correct?
Indeed.
Rather, both parties exchanged communications, and one of the communications said, please proceed to close the contract. That's what the May communication, that's the whole dispute in this particular contract. That's the whole proposition. Please proceed to close the contract. When you propose and when you then write, please close the contract, let's settle, there can be an understanding on the part of the plaintiff that when they are saying proceed to close the contract, it's going to have to do certain things on both ends. It's going to have to pay certain things, it's going to have to accept certain things from the defendant and enter into a settlement.
Indeed, Your Lordship.
Right. When they enter into settlement, everything will be given, exchanged, understood, and reached. It will have to undergo certain things and follow the principle of waiver. Waiver, intention is important, and expression is another element, which is very important. It has to be, there has to be an expression. So they knew, the plaintiff knows that it is undergoing something, it's foregoing something at the time of settlement. So now, after going through it, knowingly and stating it expressly, it cannot go back and claim the rights that it has willingly, voluntarily undergone and given up. Right? That's the spirit of settlement. It cannot also, last point that I want to make here, when it goes to the court and exchanges communications prior to approaching the court for a deposit as security, it did not raise the question of coercion or undue influence. Never once. Never once. This is purely an afterthought. And lastly, the question of coercion and undue influence, they are two separate things.
Indeed.
Economic duress. For that, allow me to read a line. It says, pursuant to the contract, SWCL released advance payment amounting to Indian rupees 10 crores on July 30th, 2024 as per clause 4 of the contract. So there could be no economic duress, which the plaintiff has itself accepted during the communications that were exchanged during the contract period. So, and economic duress is something which does not hold good in the form of commercial contracts. So, if you were to read the judgments of the Supreme Court and the citations of these judgments, one has to be very clear. In commercial contracts, you take loans from the bank and you also work on the advances that have been made to you from the defendant's side at the beginning of the contract within 20 days.
Indeed.
Of that. That's all that I want to say. So that is settlement. So in the time of settlement or during the time of settlement, the plaintiff knows very well that it is accepting and it itself has said, please proceed to close the contract. In that, there is no element of coercion, there is no element of undue influence, there is no element of, it is like, abhi main kar leta hoon, right now let me go through it with full intention and expression, and later on, when he's received the monies, it again tries to use his luck to try and extort monies from the defendant. That's what I want.
Answer. These meetings, settlement meetings have happened in May.
Indeed.
The final happened on 31st.
Indeed.
And you received your payment on 10th of June. Not mistaken.
No, 10th of June 2024, your ladyship.
10th of June 2024. So there is certainly a lapse of about 10 days, more than 10 days. Now, if indeed there is a coercion, you could have, let's say you were coerced to get into a settlement, you could have always, brought that, or, you have rescinded it to the, from that settlement right immediately thereafter. There was no need to wait to receive the money when the settlement has been acted upon. So my question to you is, can you show us that once a settlement has been acted upon, that's where you can go to the court and challenge the settlement?
Yes.
Since there were multiple questions and I understand I don't have much time, I would like to first go to the point with regards to the waiver of the rights, your ladyship.
Yes.
I understand there is a accepted legal position with regards to the doctrine of waiver, and it may or may not be applicable as well in the present matter, and that is humbly accepted by the counsel for the plaintiff. But if we look at a practical sense, if we look the condition that the plaintiff was going through, and this can be supplemented by two particular instances in the fact sheet, your ladyship. Firstly, it is when the plaintiff had highlighted its economic starvation in paragraph 4, and secondly, after the letter of termination had been given, when basically on the 2nd of April, when AGL, paragraph 8, when AGL wrote
proposition?
In the Moot proposition, your ladyship. So paragraph 4 and paragraph 8. Both of these, and the reason why I am quoting both of these paragraphs is that both of them conjointly, they tell you the economic status of the plaintiff and how severely it is being treated, your ladyship. How it has not been paid for what the work it has done, and how it is expected to also complete the milestones in the face of such economic starvation, your ladyship. And coming back to the question, ma'am, your ladyship, since there might exist a doctrine of waiver, but in the practical sense, to tell an economically starved litigant to come to the court in order to seek remedy and to arrive at court dates and to pay litigation fees and everything, which seems a little bit impractical. And it seemed a little bit impractical at that point of time, which is why it did not take any sort of recourse, your ladyship. This is my humble submission. If your ladyships are satisfied, if I may please invite my co-counsel for her issues.
You haven't answered her question.
Oh, I am so sorry, your ladyship. Could you please repeat the question?
Settlement is acted upon.
Indeed. Indeed. Your ladyship, when we look at, and I humbly apologize, your ladyship, for I got confused. I humbly apologize. However, when we look at the settlement itself, and this is what I had argued and contended earlier as well, the terms of the settlement, the process by which the settlement had been agreed upon, if that is covered under malice, if that is under coercion, then to claim that AGL had accepted the early closure of the contract under the same terms of settlement, and that should be binding upon the plaintiff without any employment of coercion, seems a little bit of challenge to the plaintiff, which is why the settlement had been challenged at a later date before the High Court of Melba, Your Ladyships. If your ladyships are satisfied with the arguments, can I please give the podium over to my co-counsel for her issues?
Please.
Much obliged.
Yes.
Speaker 2, the council shall be dealing with the remaining issues. These are issues 3 and 4. The third issue pertains to the unlawful termination of the contract, while the fourth issue is regarding the claim of loss of profit. I shall be arguing for a total time of 16 minutes. With the permission of the bench, I would like to begin with my issues before the Honorable Court today. Much obliged. Before advancing to my arguments, the council would like to give a brief structural overview of the same. For the third issue, I shall be arguing that the unlawful termination of the contract by the defendant. The council shall do so by proving that the defendant has acted in bad faith and how its non-payment prevented the plaintiff from complying with the contract. For the fourth issue, I shall talk about the claim of loss of profit and the plaintiff being entitled to the same established legitimate expectations of profit as well as due to loss of reputation and business. I shall support this argument by various case laws. To begin with, in order to ascertain whether the termination of the contract is unlawful, it is important to consider that even though on the face of it, clause 8 of the contract which deals with the termination has been complied with, the essence of the same has been debased. The termination is linked directly to the non-release of the payment by the defendant, which were raised as invoices. The council would like to contend the same by employing the concepts of prevention doctrine and of bad faith. The principle of prevention doctrine is rooted in the settled legal principle that a party cannot benefit from its own wrongdoing. Doctrine, it states that if one party, which in this matter is the defendant, prevents the other party from completing their work, the preventing party cannot hold the other party liable for the delay or for the breach of contract. The counsel of the plaintiff would like to contend that prevention doctrine is applicable in the present matter and the plaintiff is not liable for the non-performance. In pursuant of the same, if the bench could please refer to clause 4b of the contract, the subclause states that the employer is bound to make payment for each invoice that is raised. Additionally, if your ladyships, I apologize, would please refer to paragraph 4 of the facts, it is evident that the defendant failed to release the payment despite several invoices being raised, which caused severe financial distress to the plaintiff, which ultimately resulted in the non-performance. The council would further like to add that the plaintiff is also protected under section 53 of the Indian Contract Act, as it is clear that the defendant, by their non-payment, prevented the plaintiff from performing their obligations, which also in turn makes the latter eligible to ask for compensations for the losses that were incurred by them. Going on to my next argument, which is of bad faith, despite not being outwardly expressed in the Indian Contract Act, the concept of good faith and in turn of bad faith is widely accepted. It is a settled principle that every contract imposes on each party a duty to act in good faith and fair dealings for all its performance as well as its enforcement. the counsel would like to contend that the defendant has acted in bad faith, and this can be inferred from their conduct throughout the contract. The defendant's refusal to fulfill their obligations and make payments while also demanding that the plaintiff engage more manpower and more machinery, despite being appraised of the fact that the latter is suffering a severe financial distress due to the defendant's non-payment, is a clear indication that the defendant was not fulfilling its duty of good faith. It was the failure to fulfill their obligation in accordance with the mutually agreed upon contract and its untrustworthy performance of duties that ultimately led to the non-performance of the obligations of the contract.
Counsel, let's understand, let's break your argument into finer points. What is the proof of damage?
The proof of damage, if I may please refer your ladyship to paragraph firstly to paragraph 3 of the Moot proposition. It has been mentioned that the contract that the plaintiff purchased specialized machinery that was custom made for the project, and also the plaintiff also moved large scale manpower to the area of the project, and for the machinery, the machinery was worth rupees 2 crores, which the plaintiff paid from their own finances. Along with this, if I could please refer to proposition, the plaintiff on multiple occasions let the defendant know that the plaintiff was suffering through severe financial distress because of the defendant's non-payment of the invoices that were raised by them, especially due to, if I might just on a side note add, that there are a lot of financial decisions that must be taken by such a company regarding their payments to their employees as well as overhead charges, which for all of them the plaintiff obviously dependent on the defendant's payment to them. That happened monthly. Because of the delay to the same and the non-payment of the same, the plaintiff then later suffered through financial distress.
See, let's put it like this. You received 10 crores?
Yes, ladyship.
Yes. You received 10 crores and you informed them that you have utilized 2 crores for purchase of machinery.
Yes, ma'am.
Thereafter, around 7.5 crores was also released. So in total, you have got 17.5 crores. On the piece, as on paper, what you are able to demonstrate is this, that you utilized 2 crores for machinery. Okay?
Yes, lady.
And it is also true that after taking 17.4 crores, the project that you have completed is only 40%.
Yes, ma'am.
Okay. Now, under the law, in order to prove or claim for damages, what is the standard of proof? What is that you will have to prove?
Your ladyship, if I could please just again reiterate to the paragraph 4. To paragraph 4 of the Moot proposition, it must be noted that for the months, for the first 3 months of the project, that are for August 2023, September and October, the project progressed as per the milestones that were set by the defendant. This was despite the fact that the defendant had failed to pay the invoices for the months of September and for October. So the plaintiff at this juncture was working for the on the basis of the previously given sum, that was, as the ladyship has already mentioned, as well as of the invoices of the month of August. However, for the months of September and October, the invoices were not raised. Additionally, to this point, I would also like to add that the plaintiffs there was expectations of profit by the plaintiff on the end of each month for each invoice that was raised. So, not having received the same, it put them in a difficult financial situation, because of which they could not at the later stage finish the milestones as per the agreed upon contract. But I would again like to reiterate that for 2 months of September and October, without having received the invoices, the plaintiff, I apologize, the plaintiff still managed to complete the agreed upon milestones.
So how are you entitled to an LD?
Ma'am, as is already been mentioned by my co-counsel, because the issue of claim of LD is of my co-counsel. Firstly, I would like to reiterate that on the stand of it, we as the plaintiff, ma'am, if I could actually, my fourth issue is dealing with the claim of loss of profit, which also talks about the claim of loss of profit for the plaintiff as well as of delay LD and of milestone LD. So if I could answer the question when I get to that, is that okay? Much obliged. I would, if there are no further questions, I would like to begin with my fourth issue. For the fourth issue, it is humbly submitted that the plaintiff is entitled to claim of loss of profit. In order to contend the same, the counsel would like to rely on two landmark cases that have significantly contributed in the concept of claims of loss of profit, especially in the context of construction contracts. In the case, and I hope you have already received the judgment, if you could please go to the highlighted sections of the same. In the case of Unibros versus All India Radio, the Supreme Court outlined conditions for successful loss of profit claims. The counsel would like to reiterate as to what these conditions were. Firstly, that there must be a delay in the completion of the contract. Secondly, thirdly, the payment status is of an established contractor. And lastly, that there exists credible evidence that substantiates the claim of the claimant. It is the humble submission of the counsel on behalf of the plaintiff that in the present matter, the plaintiff fulfills these conditions and the counsel would like to condemn the same in a chronological manner. Firstly, it is an established and undisputed fact that there was a delay in the contract in the completion of the milestones. This is not disputed by either of the parties. Secondly, it is humbly submitted that the previously mentioned delay is not attributable to the plaintiff as their non-performance is a direct result of the defendant's failure to comply with the provisions of contract. Thirdly, it is again an undisputed fact that the plaintiff has the established status of the contractor in the present matter. And the last condition states that there must be credible evidence that substantiates the claim of the plaintiff. If your ladyships could please refer to paragraph 1 and 2 of the Moot proposition, which clearly highlights that the plaintiff is a company which won a tender that was floated by the defendant. The evaluation of the same was for rupees 100 crores, an amount which in practical and general indication gives an indication to the experience of the plaintiff. And how it can be, I would like to contend that it can be reasonably assumed that if the resources of the plaintiff were not occupied in this present project, they would have been of utility elsewhere. Furthermore, the plaintiff's investment, as I have already mentioned, the plaintiff's investment in specialized machinery custom made for this project, as well as of large-scale manpower mobilization, points towards having reasonable expectation of performance and ultimately of profit. If the bench could please refer to paragraph 3 for the same. Along with this, along with the previously mentioned reasons, I believe that the claims that the last condition is also fulfilled, and in pursuant of the same, the plaintiff is eligible to claim loss of profit. However, additionally, in order to add to the contention, it is a given that the plaintiff had legitimate expectations of profit having won such a competitive bid. If you could please refer to paragraph 41 of the memorial. In the case of A.T. Brijpal Singh versus State of Gujarat, the judgment of the same has been given. The Supreme Court observed that when a contractor bids for a tender, they expect to earn some profit if the bid is accepted. If upon execution, the employer in particular commits a breach of contract, the contract is entitled to claim damages for loss of profit against the profit that they expected to earn. And for this, I would like to give extra emphasis to the phrase of the profit that they expected to earn. The counsel of the plaintiff would also like to mention a few legal provisions to further substantiate the plaintiff's right to claim loss of profit. While the concept of loss of profit has not been specifically mentioned in the Indian Contract Act, the same has been recognized under Section 73 and especially under illustration I of the section. If I could please just read the section out. Contract. When a contract has been broken, the party who suffers from such breach is entitled to receive from the party who has broken the contract compensation of any loss or any damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract is likely to be the result of the breach. In this section, I would like to put greater emphasis on the term the damages which naturally arose. It is the contention. It is contended by the council that the loss that was caused to the plaintiff was a natural consequence to the defendant's non-payment and non-performance of their part of the contract. When a construction contract is breached, the innocent party has the right to claim damages. This includes loss of profit incurred as a result of the breach. Additionally, the defendant is bound by Section 37 of the Indian Contract Act to perform their obligations in regard with the contract entered into by the parties, which they failed to do. The contention that contractors in general and plaintiffs in the particular matter are eligible to claim loss of profit arising out of delays that are specifically attributable to the employer is further legitimized by various tests and formulas for the computation of the same that have been put into place by previously mentioned by various case laws. These tests or formulas include Achilles formulas as well as Amich's formulas, as have been mentioned in paragraph 14 of the memorial. If the bench has no other questions, and if the bench is satisfied.
Point for question of claiming loss of profit.
Yes, Your Lordship. Lordship, I apologize, Your Ladyship. In accordance with the case that is Union versus All India Radio, conditions were given. If I could, yes, thank you so much. The conditions were outlined by the Supreme Court.
You were saying there was a delay?
Yes, sir. Yes, Your Ladyship.
The grounds on which you were saying loss of profit has happened.
Yes, of course. Firstly, that if the plaintiff was not a part of this particular project, being a successful enough company to have won such a competitive bid, the plaintiff could easily apply to some other project and applied in this for this particular year, and could have earned profits from other. I mean, okay.
Isn't a valid argument to say that I could have done something else? You are in this project by your own choice. So when you're calculating loss of profit, it could be of what has been the loss of profit because of incomplete performance of the contract. Not what maybe that would become too wakeful. Right?
Yes, lady.
The aspect that you are not addressing is here it is you yourself had sought the termination of the contract because for whatever reason you thought it was not viable and feasible now that the payments are not coming forth. You thought they were not performing their part of the contract and therefore you were the one who had asked for closure of the contract.
Just this, Your Ladyship. If you could please refer to paragraph 6 of the Moot proposition. The letter for termination was given by the defendant and not by the plaintiff. So,
and your ground that you are invested in getting the machinery for the project, would it form a part of loss of profit?
So, Your Ladyship, I would like to contend the same because the machinery was bought specifically for this particular project.
You have a certain wherewithal to be able to take up a contract. Whether you already had it or you had to manufacture it or procure it cannot be directly. That's your investment. The loss of profit would be what were the potential profit margin you would have earned at the project being completely completed successfully. To say that all your overheads and everything should also be calculated, all that is a margin which you already calculate when you are bidding and you take up a contract. To say that all this will add up in your loss of profit may not give you a good answer.
Of course, Your Ladyship, it is humbly accepted. However, in addition to this, I would also like to contend that in my previous arguments, I have also stated that the plaintiff had legitimate expectations of profit, and in the case as has been mentioned, you have received, I hope, a judgment of the same. 18 Richpal Singh versus State of Gujarat, the Supreme Court observed that if upon execution of a contract, the employer does a breach of contract, the contractor would be entitled to claim damages for loss of profit against the profit that they expected to earn. And the same has been mentioned in my previous arguments, and I would like to contend the same. Additionally, as has already been mentioned, that you cannot, like, there are specific grounds as to calculating claim of loss of profit. As I had lastly mentioned, that there do exist different formulas for the same, which include Eckley's formula, Emmons formula, as well as Hudson's formula for the computation of the claim of profit, and the same will be done in accordance to that.
Which formula will you apply? You want us to apply?
Ma'am, I apologize, Your Ladyship. The most famous formula of the same is Hudson's formula. However, I must say that I am not aware of the exactly what is mentioned in the formulas and what how the computation of the same happens. But however, the most used formula for the same is Hudson's formula, and I would like to contend that out of the three of the formulas, we would like to use the same.
One last thing. There you've made very strong persuasive arguments. The only thing that finds me very confused at the end of it is, are we saying that there is a termination of the contract, or are we saying that there is settlement between the parties? So it's termination which we are referring to as illegal termination, or are we saying that there is settlement and that is full and final, because that's what is written in the Moot proposition, and we are saying the issues are whether the settlement arrived at between the plaintiff and the defendant is full and final. That's issue one. If it is in the affirmative and if it is in the negative, then whether there is, whether the settlement is vitiated by the fact that it was entered into with coercion and undue economic or undue duress. So the confusion is that if there was illegal termination by the defendant of the contract, the question of settlement doesn't arise.
Yes, Ladyship.
And because he just unilaterally, that's what I've been hearing in the arguments, that he unilaterally exercised his powers and he illegally and unilaterally. Those are the words that have been used. Illegally and unilaterally exercised his powers, and he just terminated the contract between the plaintiff and the defendant. Secondly, if that is true, then where is the question of a settlement between parties? I mean, did he withdraw? Did he revoke? What was it? And if there is no termination of the contract, then is there settlement between the parties? Because there is no, so one party has not been ousted from the contract, and then both the defendant and the plaintiff enter into a settlement with each other in May, sometime in May. And then that contract is, whether it is full and final settlement contract, that is referred to as settlement, and whether that is influenced by coercion and duress. That has yet not been made clear.
Yes,
that's all that I have to say.
Yes, Your Ladyship.
Yeah.
In order to answer your question, firstly, I have a question as well. Would Your Ladyship, are you asking if whether we, as the plaintiff, are asking for the termination of the contract to be held void, or are you asking for the settlement? I'm apologize, I have a doubt. Do you mean to say
whether there was termination at all? Because we are referring to termination being illegal and unlawful and unilateral.
Your Ladyship, the termination was unilateral. However, clause 8 of the contract states that either party can terminate the contract on their own basis.
What is its intention, plaintiff?
The plaintiff is contending that the termination, firstly, that the contract not be terminated. If the contract is being terminated, which it has already happened, because another company, which is Mensa Energy, has already been employed by the defendant for the remaining project. So we understand now that a third party is involved, that the contract can no longer not be terminated.
So that if you are saying that the contract is terminated, does the question of settlement arise? I mean, does the question that both parties entered into a settlement, does that arise at all?
Ma'am, if you could please refer to the Moot proposition, the parties did go into settlement. This happened according.
Where would be the need for the parties to go into a settlement? If one party has been ousted by way of termination, that party would cease to then exist vis-a-vis the defendant, right?
Yes.
Then why would it need to enter into settlement?
Yes, Your Ladyship. However, the contract that the termination that happened had happened before the contract was supposed to end. Because of the same, as I have already mentioned, there were expected expectations of profit by the plaintiff, and the same had not been incurred by them. Because of the same, settlement was important. What the plaintiff is stating is that the settlement that has been entered into by both the parties is not enough in the damages that has been given to them, as well as the fact that the settlement that has happened, the defendant has coerced the plaintiff into agreeing as to what the settlement was.
It has to be either or situation, right? It has to be either illegal termination, as you are alleging, or it has to be a undue influence, coercion, settlement. So which position are you taking or adopting?
Ma'am, as I have, Your Ladyship, as I have already stated in my third issue, that the clause 8, which is regards to the termination, has on the face of it been complied with. The way the termination has happened, it is complied with the contract that was set between the parties. However, the essence of the same has been defaced. This is due to the fact that in the clarifications that have been given to us, it has been stated that the termination of the contract by the defendant was done due to the delay by the plaintiff. However, it is contended by the counsel that the delay was a direct result of their non-performance of their obligations of the contract.
Okay. Thank you.
Much obliged. If the bench is satisfied with the arguments, the counsel would like to proceed with the prayer.
Yes.
Much obliged. Wherefore, in light of the issues raised, arguments advanced, authorities cited, it is humbly requested that this honorable court may be pleased to adjudge and declare that a decree be passed in favor of the plaintiff, directing the defendant to pay a sum of rupees 20 crores as loss of profit and of other opportunities during the period of unlawful non-payment. That a decree be passed in favor of the plaintiff, directing the defendant to pay a sum of 10 crore rupees as compensation for the breach of contract under Section 54 of the Indian Contract Act. That economic coercion was employed by the defendant upon the plaintiff, rendering the settlement agreement void, and pass a decree granting suitable compensation for the same, and pass any such order, writ, decree, or direction as the Honorable High Court of Melwa deems fit and proper. For this, the plaintiff shall duty bound pray. With this, we would like to rest our arguments.
All right.
Thank you.
Please do.
Same thing.
Greetings to the bench. May it please the court, this is Counsel 1 appearing on behalf of the defendant in the matter of Adhan Green Energy Limited versus Solar Water Corporation Limited. The counsel seeks permission to collectively refer to the bench as your honors. Much obliged. The counsel shall be dealing with the first contention that the settlement agreement constitutes a full and final resolution of all claims and disputes in a threefold manner, and my co-counsel shall be dealing with the second and third contentions pertaining to liquidated damages and termination of the contract, for which we respectively reserve 16 minutes. If the bench is well versed with the facts of the case, the counsel seeks permission to begin. Much obliged. Vis-à-vis the first leg of the argument, it is humbly submitted before this honorable court that the settlement agreement in question was duly signed with free consent of both the parties as per Section 13 and Section 14 of the Indian Contract Act, meeting all essentials required to enforce a contract. The plaintiff's acceptance of the terms of settlement was duly communicated to the defendant. According to Section 2B of the Act, communication of acceptance is deemed to be made by any act or omission of the party accepting or which has the effect of communicating it. Section 8 of the Act also talks about communication of acceptance by performance. Your Honours, the plaintiff, in furtherance of the settlement agreement, completed the remaining work by the agreed date, and via its email dated 31st May 2024, the counsel humbly points the court to para 11 of the factual matrix. If the bench is with me, the counsel seeks permission to proceed. Much obliged. So, as per its email dated via 31st May 2024, the plaintiff requested the defendant, the plaintiff requested the defendant to close the contract. Such conduct of the plaintiff points to an absolute and unconditional acceptance of the terms mandated under Section 7 of the Act. Further, Your Honours, Section 7 of the Act requires that the acceptance must be made in some usual or reasonable manner. In the matter at hand, communications were exchanged and conducted between in the usual and reasonable manner consistent with the parties' established practice of exchanging emails, Your Honours. Thus, all three components of acceptance as laid down by judicial precedents, which are certainty, commitment and communication, were duly fulfilled, and when all three are present, acceptance is deemed absolute, as also laid down in the case of Kilburn Engineering Limited versus Oil and Natural Gas Corporation Limited. It is pertinent to note that plaintiff, after completing their set of the contractual obligations, also received all the payments so accrued. All these payments made to the by the defendant, that too without any protest, Your Honors. And this payment that was made was for the work that they had executed up until June 10th, 2024. And this conduct of the plaintiff explicitly and implicitly points towards an absolute and unconditional acceptance of the terms. It is humbly submitted before this Honorable Court that mere existence of commercial pressure or unfavorable business circumstances does not amount to coercion. Rather than treating every instance involving a financially distressed party as duress, it is more appropriate to assess the gravity of the financial situation to determine whether it truly amounts to duress. As flows from the case of ONGC versus Daiichi Kakaria, economic duress consists of two essentials. The first one being pressure amounting to the compulsion of the victim's will, and second, the illegitimacy of the said pressure. In practical terms, as my learned opponent counsel also stated, the victim of duress must be left with no other choice. In the present case, the plaintiff had ample opportunity to negotiate the settlement, Your Honors. The entire month of May 2024 was available for discussions, during which several communications occurred between the parties. This extended period provided the plaintiff with sufficient time to review the settlement terms between the parties. Review the settlement terms, consult internally, and raise any concerns with the defendant, Your Honors. Moreover, the settlement between the parties was a result of mutual concessions, with concerns of each party being addressed and resolved adequately. Moreover,
I have a question for you, with Ben's permission. You are Solar Water Corporation Limited, a public sector undertaking, an instrumentality of state, right? You're a mighty state. How do you expect any company to stand? Can you dispute the fact that you are in a dominant position? Can you dispute the fact that you are at an advantageous position in this transaction? So why should we, when you make this argument that they had ample time, ample opportunity to negotiate a better deal with you, why should we not take into consideration the practical ground reality that there is no fair play? You are not on equal footing. You are powerful, you are dominant, and certainly in an advantageous position. Even if let's say we take you as two private parties, given the nature of transaction, you are in a beneficial position. You have 40% worked out. You have released only certain amount. The money is with you. They have executed the contract and they don't have the money. So not just from the perspective, can you please address us on these 2 points?
Much obliged, Your Ladyship. Coming to the first leg of your question, Your Ladyship, a dominant position that has been stated, we accept that we are in a dominant position here, being a state instrumentality. However, due to this, we have recognized, we have accepted the delay on our part in the months of September and October, and as a bona fide effort to act in a fair and reasonable manner with the party, we have let go of our claims of delay LD and milestone LD, Your Honors. Moreover, in order to better compensate them, better equip them to address the delay in subsequent months that was caused due to our non-payment, Your Honors, we also offered them to engage additional manpower and machinery, Your Honors. The council would humbly like to point the court's attention to para 5 of the factual matrix, which clearly states that SWCL wrote to AGEL on multiple occasions between November 23 and March 2024, asking it to complete the project and engage additional manpower and machinery to catch up with the delayed progress. Coming to the second leg of the question, your ladyship, the concept of dominant position or unequal bargaining power comes into play under section 16 of the Indian Contract Act, your ladyship. But it also has to be noted that it is only applicable when there is also an undue benefit that has been derived. In the present case, your ladyship, there has been no undue benefit that the defendant has arised. Moreover, we have inconsequentially suffered losses because we had to engage a third party at additional prices because it was in order to keep up with the delay, and we had to put in extra manpower and machinery, which caused us more loss, your ladyship. If that satisfies your ladyship's question, the counsel seeks permission to proceed. Much obliged. Moreover, the defendant had a contractual right, as the counsel on behalf of the defendant already mentioned, to claim delay LD and milestone LD, which it voluntarily waived off in order to accommodate the claims of the plaintiff. The parties entered into the settlement in good faith without any form of duress or coercion. Economic pressure only rises to the level of economic duress when it constitutes illegitimate pressure, your ladyship. As laid down in the case of Hudson Agro Products Limited versus Industrial Development Bank of India, assuming that accepting reduced compensation due to financial challenges alone constitutes duress, sets a dangerous precedent. Such an assumption could lead to a scenario where parties to a contract who voluntarily entered into supplementary agreements later claim that they acted under duress simply because of unfavorable financial conditions, your honors. Your honors, where coercion is alleged, detailed particulars must be given in the pleadings. Mere economic pressure alone does not amount to coercion unless there is clear evidence of unlawful threats. In the present case, the plaintiff has failed to produce any evidence of unlawful threats or coercive behavior by the defendant that would force them into accepting the terms of the settlement. The counsel seeks permission to drink water. Apologies, your honors.
Counsel, I would like to ask you if you've included in your arguments the nature of an employer-employee relationship in coercion or undue influence?
The counsel seeks permission to get back to your honors in this after referring to the written submission and then pointing out exactly.
Okay. All right. Thank you.
Much obliged, your ladyship. Your honors, furthermore, all actions taken by the defendant were legitimate and fell within the scope of the contractual agreement. The defendant's engagement of Mensa Energy and subsequent reduction of the scope were commercially justified due to the plaintiff's underperformance, your honors. Hence, no illegitimate pressure was exerted on the plaintiff. The bargaining and acceptance of an offer in the context of financial difficulties cannot be treated as duress, as recognized in the case of Double Dot Finance Limited versus Goyal MG Gases Limited. Your honors, a rational choice between two alternatives cannot be construed as a decision made under duress. It is humbly submitted that the defendant was not in a position that could have been exploited to gain an unfair advantage, your ladyship. The principle of dominant position, as the counsel has previously also as the counsel would like to reiterate, the principle of dominant position in a contractual relationship only applies when such dominance is used to derive undue benefit. Herein, in this case, the defendant did not gain any unfair advantage from the settlement and, on the contrary, suffered significant losses. Proceeding to the second fold, these facts clearly demonstrate that the defendant did not use its position to exploit the plaintiff, but instead incurred substantial setbacks in its efforts to move forward with the project. It has been laid down in the landmark case of Sara International Limited versus Rizau Steel Holding Group Company that the plaintiff, having failed to raise an objection of economic duress at the first available opportunity, or where it is shown that the consent was arrived at upon due consideration, an allegation of economic duress cannot sustain. In the case at hand, no objections to the settlement agreement were raised by the petitioner. Rather, the petitioner duly complied with the terms of the agreement. Moreover, proceeding to the second leg of the argument, it is humbly submitted that the defendant is a PSU, public sector undertaking, discharging functions in pursuance of public policy. As per the landmark case of Central Inland Water Transport Corporation versus Brojonath Ganguly, the expression connotes some matter which concerns public good and public interest. Interests of public, Your Honours, outweigh those of private individuals, and in its broadest sense, public policy means that sometimes the courts will have sometimes the courts on considerations of public interest may refuse to enforce such contracts. In the case at hand, the defendant had undertaken the project of development of solar water desalination plant in order to solve the water problem of the district of Melva. Thus, the timely completion of the project was of utmost significance. And given that it involved public interest, it was important that the contract be interpreted to safeguard public welfare. And the same principle has been also applied in the case of ONGC versus Saw Pipes Limited. Proceeding to the third leg of the arguments, Your Ladyship, it is humbly submitted that the doctrine of clean hands is applicable in this case. In the instant case, the plaintiff actively accepted payments released in pursuance of the settlement agreement. Moreover, it also enjoyed the benefit of relinquishment of the applicable liquidated damages. The acceptance of these benefits undermines any claim of duress. Rather than, it signifies consent rather than coercion. A party cannot claim a contract is void due to duress after having taken the benefits that arise from it. This has been upheld in the case of AP Transco versus Sai Renewable Power Limited. If the bench is with the council on this, the council seeks permission to conclude.
Yes.
To conclude, the settlement agreement was executed with free consent of both the parties. It is evident that the parties voluntarily agreed to the compromise reached to settle the dispute, and as held in the case of National Insurance Company versus Bogra Polyfab, such settlements should not be lightly disturbed. Thus, the settlement agreement was a full and final adjudication of all claims and disputes. Council humbly seeks permission to address certain points that my opponent co-counsel had raised in their submissions. Much obliged, Your Honours. Your Honours, my learned colleagues have cited section 54 of the 51 of the Indian Contract Act dealing with reciprocal promises. However, they have failed to recognize that a compensation has been provided by the defendants in two ways. Firstly, when we offer them to engage additional manpower and machinery that will be required to meet the milestones charted out, and secondly, when we waived off their milestone LDs which were applicable. The council seeks an extension of 30 seconds. Secondly, Your Honours, as my learned opposing counsel also stated in their in their submissions that the company AGEL was a successful bidder, and they had been seeking for bids in order to carry out these contracts. It is to be noted that if a company enters into an e-tender of such a large scale, it is presumed that they will have financial resources to sustain the production for 1 or 2 months. Because we being a public sector undertaking, we humbly accept that the fault lies on our part. However, as a PSU, we have a hierarchy in place, and this hierarchy sometimes leads to inordinate delays which are beyond our control. But in order to take bona fide steps to address those shortcomings, we have made bona fide efforts, and thus the termination of the contract is justified because of negligible progress made by the petitioners. It was an honor arguing before this honorable bench.
Yes.
Greetings to the bench. Am I audible? The council shall be dealing with the second and the third contention pertaining to the entitlement of delay in milestone LD and the alleged unlawful termination of the contract. Honorable judges, the council respectfully submits before this court that the defendant's claim for delay LD and milestone LD is fully justified under the terms of the contract and the applicable law. This contention rests on three key arguments. Firstly, Your Honor, at the foundation of the defendant's claim for delay LD and milestone LD is the established principle that time is of the essence in this contract. Clause 5 of the contract explicitly underscores that all milestones must be achieved by specific deadlines, reflecting the mutual understanding of both the parties regarding the critical nature of timely completion. As my co-counsel had mentioned the reciprocity clause, they failed to mention section 55 of the Indian Contract Act as well, where it is clearly mandated that when time is specified as essential, any breach justifies termination or damages, Your Honors. Moving further, the project in question involving a SONEPAT seawater desalination plant for addressing water scarcity in Melva serves a substantial public interest. Your Honours, the exigency of this project required strict adherence to timelines, with both parties recognizing that delays would incur severe consequences, including resource shortages and increased costs. Your Honours, as seen in the case of ONGC versus Saw Pipes Limited, it upheld that liquidated damages provisions, especially when time is essential, confirming that the defendant is entitled to claim delay LD and milestone LD due to the material delays caused by the plaintiff's non-performance, Your Honours. Moving further, the contract further specifies liquidated damages for each delay beyond a permissible limit, with a predefined rate per month of delay. Your Honour, this provision sanctioned under Section 74 of the Indian Contract Act allows reasonable compensation, particularly in cases where time restraints are strictly outlined in the contract itself. Thus, the defendant's claim is consistent with the Indian contract law provisions and a lawful exercise of the liquidated damages clause.
Counsel, I have a question.
Much obliged, Your Honor.
In fact, in two parts. First is this, when you talk about that there was an understanding by both the parties that time is of the essence. What is your answer to clause 4B, which puts an obligation on you to make a payment within 30 days of raising receipt of the invoice, right? Now, the milestones is the next clause in the contract. So if I have to read it, and I'll go, if we go in the order in which the contract is before us, it appears that one of the what comes before the milestone is the payment of the invoices. Okay. So how do you, question one, how will you sustain the argument that you're making now if you have not honored the invoices within 30 days, as is expected under clause 4B, first? Secondly, when you're talking about LD and you're referring to the clause in the contract, your case, if they are referring to it, I can still understand, but you are relying on the settlement that you have already acted upon. You're basically trying to say that the settlement should be sustained. Then why this argument on the LD?
Much obliged, Your Honours. The Council would like to answer this in a twofold manner. Firstly, Your Honours, regarding the delay in payments, the defendants completely agree that the fault was on their part, and for the same, as I would like to refer the bench's attention to paragraph 6 of the factual matrix, has condoned for the same. As according to clause 5 of the contract, the milestones that had to be completed till April 30th was 72%. Your Honours, but in the pertinent matter, according to the termination letter that was sent on 1st April, firstly they were given 30 days to fulfill the obligations that were written in the letter. Alongside the same, Your Honours, the scope was reduced to 50% from 72%, keeping in mind the delays that were because of the defendant in the pertinent matter. Answering the second leg of your question, Your Honors, regarding the milestone and the delays, if I could again refer Your Honors' attention to clause 5 of the contract. Your Honors, by October 31st, 2023, till the time the delays were made in the payments, 24% of the project was completed according to the milestones. Your Honors, by March 31st, 64% of the project should have been completed, whereas only 40% of the work had been completed, which brings us to the conclusions that for the 5 months, including November, December, January, February, and March, only 16% of progress was held in the pertinent matter, which brings us to the conclusion barely 3% of work was being done in every month, which lacks proportionality to the delay that was caused by the defendant in the pertinent matter. Moving further, answering further to your questions, Your Honor, regarding the issues raised in the LD, I would like to refer Your Honor's attention to paragraph 13th of the factual matrix, where it is one of the issues listed that under clause B, that if the answer to the first issue is negative, whether SWCL is entitled to claim delay LD and milestone LD from AGL as per the contract. Your Honors, according to section 62 of the Indian Contract Act, any novation, cessation or alteration in the contract must be bilateral. And if a new contract has been made, the old contracts get substituted for the new one. Your Honor, in the pertinent matter, what we are seeking is, if the restoration of liquidated damages, if the settlement agreement is set aside, then the restoration of liquidated damages should also be reimposed. If that satisfies Your Honor's question, I would like to proceed with the arguments. Your Honors, the defendant's right to claim both delay LD and milestone LD is reasonable and non-punitive. It is essential to note that these LDs were designed to ensure timely performance, and they were agreed upon as deterrents to avoid any setbacks in the project. As already emphasized, how time was of the ultimate essence. Your Honors, the defendants seek these LDs not as a penalty, but as a genuine re-estimate of the losses that were suffered due to delays. To justify the same, Your Honors, the rates of 1/3% and 1/12% were established as reasonable and proportional figures based on industry standards for the liquidated damages. These rates serve as a safeguard against the financial implications of project delays, which might include increased project management costs, administrative expenses, or resource allocation. Your Honors, the small percentages are a calculated reflection of these anticipated costs, ensuring that the defendant has some compensation for the delays, even if the exact costs cannot be precisely mentioned at the time of contracting. By anchoring the liquidated damages rates within established commercial standards for government-led infrastructure projects, the defendant acted in accordance with the Supreme Court's directives, further substantiating the validity and fairness of these claims. Your Honors, preset liquidated damages are essential in public projects to mitigate non-performance risks and provide immediate remedies in time-sensitive settings. This protects the defendant's interest in the project's timely completion while also minimizing administrative burdens by establishing a clear-cut remedies for delays that impact essential milestones. Again, reiterating what the Council had already said before, that under Section 62 of the Act, any waiver or alteration in the contracts must be consensual and remain enforceable only upon agreed mutually terms. If the settlement agreement under which the defendant waived the delay LD and milestone LD is set aside due to alleged coercion or duress, the original LD terms would be reinstated. And the defendant's waiver of LD was a good faith gesture. However, should this court set aside the settlement agreement, the defendant's right to claim LD would be restored, as this was a concession provided in lieu of the settlement. Your Honor, if Your Honors have no further questions, I would like to move on with the third contention. Honorable Judges, I submit that the termination clause within this contract is both valid and enforceable, supporting the defendant's decision to lawfully exercise its right to terminate the contract. Your Honors, the defendant's termination of the contract is fully compliant with the terms stipulated in clause 8 of the factual matrix, which grants either party the right to terminate with the contract with a 30-day notice. Your Honors, the termination notice dated April 1st, 2024 gave the plaintiff adequate time to complete remaining work by April 30th, 2024 and specifically required the plaintiff to adhere to the original schedule for completion. Your Honors, at this point, I would like to refer to Section 39 of the Indian Contract Act, which permits termination when a contracting party fails to perform its obligations. Your Honors, the respondent's decision therefore complies with the statutory requirements supported by the case of Classic Motors Limited versus Maruti Udyog Limited, where persistent delays in performance led to lawful termination. Your Honors, here the plaintiff's repeated inability to meet the milestones justifies the defendant's action, positioning the termination as a reasonable and lawful exercise of contractual rights. Your Honor, a party's contractual termination rights remain protected when the opposing party's non-performance causes operational impediments to the project completion. Your Honors, here in the pertinent matter, therefore, the defendant's action aligned with contract law principles and a legitimate termination right under the established legal principles. Your Honors, the defendant's decision to invoke the termination clause rests on a fundamental principle upheld by the Supreme Court in Nabha Power Limited versus Punjab State Power Corporation Limited, in which the court stated that the explicit terms of a contract are always the final word with regard to the intention of the parties. Therefore, the court must defer to the language of the contract if the terms are unambiguous and clearly stated. Your Honor, the termination clause in question is an explicit term mutually agreed upon by both the parties designed to ensure timely and efficient execution of public projects. In this case, the clause was exercised in a manner consistent with its purpose to address significant delays in the project timeline. Moreover, as a public sector entity, the defendant is obligated to act in good faith, protecting public funds and ensuring timely delivery of projects. Your Honors, the termination clause provides the defendant with a necessary safeguard to mitigate losses and delays arising from significant performance failures. The defendant's invocation of this clause was driven by the imperative to manage public resources efficiently, particularly since the delays in the plaintiff's performance would have required the defendant to expend additional resources to complete the project on the schedule, which did happen eventually in this project, Your Honors. The defendant's use of the termination clause was both lawful and within its rights. The plaintiff's inability to meet the contractual milestones posed a tangible threat to the defendant's ability to fulfill its obligations. The termination clause, as an explicit term mutually agreed upon, was invoked in good faith to address these concerns. The defendant, therefore, respectfully requests the Honorable Court to uphold the validity of the termination as an essential exercise of contractual right. Moving further, Your Honor, the termination clause within the contract is explicit, legally binding, and essential to the defendant's prerogative to manage public projects effectively. Moving forward to the next leg of the argument, Your Honor, there is an absence of evidence in the plaintiff's claim for lost profit and opportunities. Your Honor, Section 73 of the Indian Contract Act incorporates two rules. Firstly, the damages which the other party ought to receive in respect of such breach should be as may fairly and reasonably be considered either arising naturally, according to the usual course of things, from such breach of the contract itself, and secondly, such as may be reasonably be supposed to have been in the contemplation of both the parties, Your Honors, at the time they made the contract as the probable result of the breach of it. And this was held in the case of the Andhra Pradesh Mineral Development Corporation Limited versus Potem Brothers. Your Honors, the plaintiff's claim for lost profit and consequential damages falls under these principles. Firstly, the delay in project completion was a direct result of the plaintiff's inability to meet the project milestones, as they only completed 40% of the work by March 2024. Well below the contract requirements, despite repeated notices from us to expedite. Your Honors, the defendant, who is also the employer, could not have foreseen such a significant delay due to the plaintiff's performance issues and could not have anticipated the speculative financial strain that they now allege. Furthermore, Your Honors, the defendant itself incurred additional costs due to this delay. To mitigate these losses and ensure timely project completion, we engaged Mensa Energy at higher cost to meet the essential deadline of 31st July 2024. With time being of the essence in this contract, we faced both increased financial burdens and logistical challenges due to the plaintiff's failure to fulfill contractual obligation, requiring additional resource and planning on our part. Your Honor, it was through our goodwill that and practical approach that we refrained from claiming these additional costs in the settlement agreement. Given this, the plaintiff's claim for lost opportunities and future profits, which are speculative and unsubstantiated, do not align with Section 73's limitation on recoverable damages and must be dismissed. Damages are limited to immediate losses traceable to the breach and not hypothetical opportunities, Your Honor. The Supreme Court, in the case of Kailashnath Associates versus Delhi Development Authorities and others, observed that wherein a contract has provisions for liquidated damages, such amount can be received in totality only if the amount of damages suffered by the aggrieved party is similar to the pre-establishment of such damages. The court further observed that the quantum of damages awarded by the court should at no point exceed the amount mentioned in the contract in the form of liquidated damages. Your Honors, the plaintiff's claim for loss of profit towards loss of profit and opportunity is speculative and unsupported by objective evidence. Under Section 3 of the Indian Contract Act, compensation for loss or damage must be direct and quantifiable. The plaintiff's claim for lost profits lack financial records, projections, or other substantive documentation to substantiate actual damages. The counsel seeks a extension of 1 minute, if Your Honors may proceed. Thereby failing the requirements established in Kailashnath Associates versus DDA, which mandates credible evidence for profit loss claims. At this point, Your Honor, I would like to seek reference to the Hudson formula, as my very learned opposition mentioned. According to the Hudson formula, Your Honor, the damages that must be awarded should be an actual re-estimate of the losses, and they should hold any substantial value, which in this case which in the Portman matter is not the case, Your Honors. With this, I would like to conclude. In conclusion, Your Honors, the defendant's claim for delay and milestone LD is grounded in contractually sound and legally sound principles under the Indian contract law and under the contract that was executed between both the parties. Given the plaintiff's persistent delays and the defendant's adherence to good faith efforts, the defendant's entitlement to liquidated damages reflects both a reasonable estimate of losses and an enforceable contractual right. Similarly, the termination was lawfully executed and the plaintiff's claim for speculative profit and opportunity losses lack credible basis under the law.
For claiming LED, have you find a counterclaimant and have to quantify the amount that you claim?
Massive light.
One argument has been that they quantify that they are. Have you done?
Much obliged, Your Honor. The concept of liquidated damages is dealt under Section 74 of the Indian Contract Act, which clearly stipulates that whenever damages are to be released as liquidated damages, they should be in pre-estimate. Your Honor, this was the provisions for delay LD and milestone LDs were mutually agreed by both the parties according to the contract that was executed by both the parties. These rates, as the counsel has already dealt with before, there's a safeguard against the financial implications of project delays and were established as reasonable and proportional figures based on industry standards, which included increased project management costs, administrative expenses, or resource allocations, Your Honors. Whereas the damages that the plaintiffs are seeking falls under the purview of Section 73 of the Indian Contract Act, which states that damages shall be awarded to a party which has suffered losses due to the breach of a contract, which in this case, Your Honor, is not the case. Your Honors, both the parties mutually entered into the settlement agreement, and for which the benefits and obligations have been satisfied by both the parties. If that satisfies Your Honor's questions, I would like to proceed to the prayer. In the light of the facts of the case, issues raised, arguments advanced, and authorities cited, The counsels on behalf of the defendants shall humbly pray before the Honorable Court to kindly adjudge or declare that the suit shall be dismissed and or pass any other order that the Honorable Court may deem fit in the light of justice, equity, and good conscience. And for this act of kindness, the counsels on behalf of the defendant, as in duty bound, shall forever pray. It was an honor arguing before the Honorable Court here. Honors.
The council understands that there are only 3 minutes for rebuttals, and I shall be quickly stating the points. Some of these points have already been addressed and asked by your ladyships, but just to reiterate a few points before passing the final judgment. Firstly, and very pertinently, the prayer, as my learned co-counsel just said, and what has been written in their written submission as well. And if your ladyships may please refer to their prayer as given in their memorial. There are two other points that they have conveniently skipped in their oral arguments as well as in order to justify or in order to substantiate why they have written those points. And they are very important because if points A and points C are to be considered together, if the finality of the settlement agreement is prayed for by my learned opponent, then there is no claim for delayed and milestone entry, because that was the entire point of the settlement agreement, that if the settlement agreement is accepted, there is no milestone and delayed LD. But they have asked for all three of these points, and there is no application for the amendment of their plaint as has been received by I believe your ladyships or the opposing counsel as well, which states that their prayer has been further amended as has been just stated by my opposing counsel. Firstly, and these 3 points are in continuation or in connection with each other, and the main point of these points is practicality. Practicality is what has to be considered for the conduct of the plaintiff and for the conduct of the defendant as well. When my learned opposing counsel argued that there was ample opportunity in May 2024 for the plaintiffs to amicably or in order to fight for their own rights, in order to obtain an equitable decision or an equitable settlement agreement, what they failed to understand very respectfully is that there was an availability of time, but there still was a shortage of funds, which was the primary reason why we had to agree to the settlement. If this is to be considered, and therefore the reason why the plaintiff in the first place agreed to the settlement is because it had suffered so much economic starvation, and I can highlight this with the facts of the present matter as well. Firstly, September and October payments are given at the end of March 2024, then the work completed from November to March is paid in June. So there are a great number of months which have remained uncompensated for, and then my learned opposing counsel says that the month of May was just was enough for us to ask for an equitable settlement just based on the time of us seeking that remedy. Fourthly, and this is my last submission for your ladyships, is that learned Madam Counsel also stated that given the nature of the company, given the nature of the plaintiff, it is also to be taken, it is also considered, or it should just be taken as a matter of fact or de facto, that we must have funds of ourselves to complete the work for a few months of our own, even if payments are not to be made, which is this is out of the scope of the present matter, because how AGL handles its finances, even we have not referred to, because that is out of the scope. Some companies completely invest all of their earnings that they have into other projects. Some companies have a specific surplus for the same, and since this is out of the purview of the present factual matrix, it is just humbly submitted that for the defendant to ask just one final settlement, your ladyship, for the plaintiff to ask for such a thing is out of the scope. And just as a final settlement, my learned opposing counsel also time and again claimed that time is of the essence, and it also and the defendants also claim that the obligations of the contract were mutually agreed to by the parties. If there is actually mutual obligations, and if there actually is also consent from the defendants about the terms of the contract, then time is of the essence also applies to them. It also applies to their non-payment of September and October, which has been conveniently ignored by my learned opposing counsel. With that, I would like to conclude, and it was a pleasure arguing before your ladyships. Much obliged.
Your Honours, as my opposing counsel made the claims of us claiming delay LD and milestone LD alongside the adjudication of the settlement agreement. Your Honors, as I have argued, as the counsels for the defendant have argued before the Honorable Court, the clause for delay LD and milestone LD should only be restored if the settlement agreement is set aside, as already been dealt by the defendant, by the counsel. Coming to the second point, Your Honors, the 40% of the work that was done, they were paid for it. There was delay on our part, and we have accepted the delay, and for the same, we have also condoned them for the same. And regarding the same, as I had referred to paragraph 6 of the factual matrix, the scope was significantly reduced and the payments were also released. Also, a factual error that was committed by my opposing counsel here. By the end of March 31st, all the payments in March were paid, as given in paragraph 5 of the factual matrix. And alongside the same, there was no communication from the plaintiffs regarding any financial distresses from November till March. Your Honors, it has been an established practice between the plaintiffs and the defendants to communicate any grievances that have been there since the very beginning of the contract. This has happened in various instances, including the time when we told them to engage additional manpower, and the subsequent matters that followed. Whenever they have raised a grievance, we have acknowledged those grievances and acted accordingly. Your Honors, the defendants have only acted in accordance to the law and in accordance to the contract that was mutually agreed upon by both the parties. Coming to another point that my learned co-counsel opposed, Your Honor, of time being of the essence, has already been dealt by the counsels, Your Honor. We have accepted our mistake in delaying the payments multiple times here in this court today, and have also established how we've condoned the delay for the same by reducing the scope of project that they had to do, and for the same, and for the non-payment of the same as well. And with this, the counsels on behalf of the defendant conclude their arguments.
You said you gave a notice of termination. Was it because they were unable to complete the work?
Your Honors, the termination notice that was sent to them was due to their inability to complete the project milestones on time.
You're making the contract in April, your first April. It also says that you cannot cut down the work more than 36%. But what is the trend suffered by the plaintiff here? 40% is done. So how much is the work which has been left undone?
50%, Your Honors.
60?
Your Honors, 10% of the work.
But it could not have been reduced below 36%.
Much obliged, Your Honors. For this answer, Your Honors, the terms of the contract, these were disputed by the plaintiffs as well. And we held negotiation meetings with them. We did not reduce the scope arbitrarily till then. And further, in the settlement agreement, these terms were discussed upon and agreed upon by both the parties, and through which this clause comes into action.
How do you say that?
Your Honors, as it is clearly stipulated in the contract, mentioned. Your Honor, the nature of the work also comes into consideration here, and the fact that we had to engage Mensa Energy at a higher additional cost to compensate for the delay that had been caused for the project completion, as the completion date could not have been challenged or changed.
You were time and again admitting that you are not making the payment. If you are not making the payment, how do you think the other party can proceed? As there is no guarantee that you would ultimately pay. If this person makes an investment of 1 CR in completion, tomorrow you turn around and say, I'm not paying. Where does the plaintiff go then? So are they not justifying in slowing down the completion or meeting the milestone because there's no money coming from you to say that you have given it belatedly or that you are a PSU, that delays are inherent in your functioning? What kind of argument is it?
Much obliged for your question, Your Honors. Regarding the point that our delay, that time was not of the essence due to our delay in payments, Your Honors, time was of the ultimate essence in this matter, and having condoned our delays multiple times, we had acted in good faith and reduced the scope according to paragraph 6 of the factual matrix, in which, as I had stated before, 74% of the contract should have been completed by April 30th, 2024, whereas all we stipulated was just 50%, condoning the delay and accepting the delay that we had done in our payments. With this, I rest my case, Your Honor.
Can we have 5 minutes to compile?
Please.